Welcome to FCS Dublin 2018. Delegates and incoming speakers, welcome all. And also I'd like to welcome the Chief Justice of Ireland, Mr. Justice Clarke, whose presence with us is a great honour. Justice Clarke, not alone as the Chief Justice of Ireland, is the Chief Justice of the only remaining fully common law jurisdiction that would exist in the EU after Brexit, but whom last March was appointed by the European Council under Article 255 of the Treaty on the Functioning of the European Union to the panel to appoint judges to the courts of the European Union in Luxembourg in the common law slot that was historically filled by a member of the UK Supreme Court. That role of bearing the common law torch in the European Union of 27, with the practical support, as it were, of only two other countries which have common law tradition, Cyprus and Malta, both of whom have mixed civil and common law systems, on the face of it would seem to be a daunting challenge. But as a reading of Chief Justice Clarke's important address on these topics at Fordham University in New York last month would make clear, he for one does not seem at all overawed by the challenge. On the contrary, he advocates for the opportunities to bring the benefits of our common law tradition to in the commercial sphere, to whatever future European configuration history will bring. This is a source of great encouragement, and one I think that the financial services industry will appreciate. At our summit tomorrow, we will be discussing the special session addressed in a paper by the outgoing chair of the, I stand to correct myself on that, the former chair of the Bar Council, Paul McGarry, SC, and with a panel of distinguished lawyers, a number of the opportunities that exist in which the Chief Justice himself addresses in his Fordham paper. Amongst these, we will be discussing the ISDA derivatives master agreements and the very interesting possibility the Chief Justice suggests in his paper of the potential of the Irish model of examinership as an eminently suitable model in a pan-European context, potentially for international insolvency resolution. These potentially all could see the increased role of Irish courts in the future, referencing, for example, the new ISDA master agreements and the Cape Town Convention, for example, also, which is of huge importance to Ireland's aircraft leasing industry, indeed, the world's aircraft leasing industry. In discussing, as we will at the summit, the relative resources and strengths of different centres and jurisdictions, we emphatically don't start from a position of eating other people's dinners or poaching business that might be displaced by ruptures such as Brexit. Our emphasis is to highlight the special advantages and special solutions that can be achieved in the different centres to the benefit always of the end client, and best regulation in financial centres of quality. Our motto is the zero plus other than the zero sum solution. And the presence here of speakers and delegates tomorrow and tonight, centered right around the world, is evidence of that. And may I also welcome you all here today, and to say we are greatly looking forward to sharing our insights in our sessions tomorrow. Thank you all for joining us, and thank you all our sponsors, our speakers, contributors, and you, Justice Clarke. Now, may I conclude by enthusiastically recommending the Chief Justice's Fordham paper. We have it reprinted on full on our website. And I, for one, greatly look forward to traveling those ideas in the time to come. Now, Karen Reynolds, a partner in Matheson, one of our partners, is also here with us. And Karen, I know, is an enthusiast for a lot of the work that Chief Justice Clarke has done in the past. And she would love to join me in maybe referencing some of these points and just say a few words to expand.
Thanks for having us here for the great attendance this evening. My name is Reynolds. I'm a partner in Matheson's Regulatory Investigations Group. Matheson with EY are delighted to sponsor the summit for the second year. And just want to say it's a credit to the work that's gone into the organisation, the calibre of speakers and the calibre of attendees that we have here. And I think today and the next few days will be an insightful time for conversation. A couple of remarks. It just strikes me how we are certainly living in an era of disruption, and the themes of this year's conference, finance and financial centres, the outlook to 2025 and beyond, is certainly apt in light of that era of disruption, and particularly in financial services. We, advisors to financial services providers and those who consume them, are constantly innovating and changing. And I think it's incumbent on all of us to engage in conversation, educate each other, those who consume our services and who regulate us about the business that we do and the environment that we operate in. That's why forums such as this, I think, are great, and it's great to be involved in them and to have a seat at the table and to be part of the conversation. I think, again, it's really important for Dublin to hold its own in this changing environment, that we continue to embrace change and disruptive technologies. And I think for these reasons in particular, it's great to have the privilege of having Chief Justice Clarke here to welcome the attendees. I think Chief Justice Clarke is an innovator and a disruptor in his own right. He was appointed the 12th Chief Justice of Ireland on the 20th of July 2017. And a degree in maths and economics, he certainly speaks the language of business and finance. I had the pleasure of meeting the Chief Justice in New York earlier this year. And a proud Dubliner, he is committed to promoting Ireland internationally as a centre for legal services. In playing his part in disruption and ensuring Ireland keeps pace with change, the Chief Justice marked the opening of this new legal year by announcing for the first time that the Supreme Court will become an e-court with online filing of appeals and submissions. And the Chief Justice is committed to developing plans to build a modern motorway for practitioners. He has also revealed discussions that have begun around allowing the broadcasting of legal argument to the Supreme Court following a successful pilot last year. So I'm sure you'll all agree that as a country and a place in which to do business, we're lucky to have the Chief Justice as an innovator and disruptor in his own right. So with that, I'll hand you over to Chief Justice Clarke.
I'm pretty sure that all of my colleagues like the idea of being disrupted in quite the way that, but I'll take the compliment. Firstly, can I say how happy I am to be able to be part of this welcoming ceremony for the conference. Brexit is obviously the topic on a lot of people's minds in Ireland at the moment, and I think it's probably fair to say that no version of Brexit is likely from an overall perspective to be anything but negative from an Irish point of view. I find it difficult to conceive of any outcome other than Brexit not happening that would be not significantly negative from Ireland's perspective. But that doesn't mean that it is negative across the board. And it seems to me, from a national point of view, what we need to do is to identify ways of mitigating the harm in those areas where there will undoubtedly be harm, but also identify sectors and areas where opportunities arise and do our best to exploit those so that the net effect will be as minimally negative as is possible. And curiously, I suspect the areas of finance and internationally traded legal services probably represent two of the areas where there are potential for counterbalancing gains from the Irish point of view. I don't have the expertise to speak about the financial services end of things, but we know that a number of significant financial services companies have announced movement of staff, movement of particular sectors into Ireland, while at the same time there are many competitors in that regard, Frankfurt and the like. And I think the same in one sense can be said for legal services. I I don't think that the provision of internationally traded legal services, including litigation in London, is going to stop overnight. London has great expertise, it has a great reputation internationally, it's not going to disappear. But there are probably some elements of the package which may not be comfortable in being deployed in a non-EU country, and that, I suppose, provides the opportunity from Ireland's point of view. As the ISDA standard agreement shows, there's an appetite for remaining within the EU, being in a common law and English-speaking country, so that if you go to litigation, you're dealing with a court system with which you're broadly familiar, you're dealing in a language with which you're familiar, but you have the benefits of operating within the EU. The Fordham address took about 50 minutes, so this is not going to take anything like as long as that. If you want the full version, as has been said, it's available for anyone who has sleepless nights tonight and needs to look up the detail of various European measures that may be of some relevance. But I'd like to highlight maybe 3 points that derive from what I said in Fordham. The first is that I think that the disruption that is likely to be caused to legal systems by Brexit is perhaps a topic that hasn't been focused on to the extent that it perhaps deserves. It's understandable that from an Irish perspective, things like the border issue is hugely to the forefront of people's minds. Movement in financial services has obviously been the topic of some debate. But I think what's often missed is that even in areas that aren't particularly controversial, the 40-odd years that we have all been members of what was once the EEC and is now the EU has led to a great intertwining of legal systems and legal issues. There were plenty of things that worked reasonably well on a bilateral basis in the past, when we had extradition from one country to another, and that worked okay. But what has happened in 40 years of membership of the EU is a lot of that has been abandoned and replaced by, in the case of extradition, for example, the relatively streamlined European arrest warrant system. Now, there's no reason in principle why we can't go back to having an extradition treaty between Ireland and the UK if the UK leaves the EU in circumstances where the jurisdiction of the European courts in relation to European arrest warrants no longer runs. But someone has to negotiate that treaty. Is it going to be negotiated by next March if there's a departure without an agreement? I'd be very surprised. The recognition of legal qualifications. When I was a young barrister, there were arrangements between the Irish bar and the English bar for mutual call on fair and easy terms. They got subsumed into European mutual recognition arrangements. Irish solicitors had similar arrangements. And the list goes on and on. These are only the bits of the picture that I'm personally familiar with. And I think it's perhaps missed that there is a huge level of intertwining across a whole range of areas, which is capable of being put together again, but it will take time, and certainly not capable of being done within a very short time frame if there's a very rapid departure from the EU without some form of ongoing transition agreement. And even then, a lot of what may replace what's currently in place may be more complicated. I know some studies have been done both in Ireland and other countries that suggest that the judicial and court resources required to deal with a typical extradition application is somewhere between 2 and 3 times as much as is needed to deal with the typical European arrest warrant. And clearly, given proximity, a reasonable chunk of our extradition stroke surrender applications come from the UK. So even that is a challenge to us if we have to go back to doing old-fashioned extradition. And we do extradition, we do it to the US and we do it to other countries that are not within the European arrest warrant system. So there's no problem dealing with it, but it just is going to be more complicated. And that is replicated across a whole range of areas. So the first thing I'd like to say is I think that it is going to be much more legally disruptive than people give it credit for. And even if there is a relatively coherent deal, any lawyer, I think, knows that any new set of arrangements takes time to bed in. There will always be issues of interpretation, there'll be issues of practice, there'll be issues of how things are going to work in practice. So that even if you have a relatively comprehensive deal, there will be debate about what it means, what new measures, how they're to be interpreted, how they're to be applied in practice. So I think on any view there's going to be a period of uncertainty, lasting for quite some time, and that's even if there is a relatively coherent departure arrangement entered into. So that's perhaps the first issue. The second issue is to emphasise what I think are opportunities for Ireland. Obviously, there is a limit to the capacity of any country to expand without interfering with quality, the amount of any particular activity it does. But I think I can speak with some confidence about the Irish courts, and in particular in their commercial context. I spent 7 years as a judge of our commercial court before I was promoted to the Supreme Court in 2012. And I think it's fair to say the Irish Commercial Court has a high reputation as a court that delivers first quality litigation services in large-scale commercial litigation. And one anecdote I was just referring to in conversation before coming up here, I think illustrates that fact. I was involved as a High Court judge in the commercial court in dealing with a series of significant claims arising out of the collapse of the Madoff empire in the US. The total value of the claims was on the north side of €1 billion. There was parallel proceedings in the Southern District of Manhattan, which is the US federal trial court. And as you can imagine, the southern part of Manhattan, Southern District of New York includes Manhattan, therefore includes Wall Street, and it therefore is the part of the US federal courts that deals with an awful lot of high-level financial litigation. The interesting question arose as to whether it was appropriate legally, both in US law and Irish law, to have these two cases running, because there was a very significant overlap between them. And the interesting outcome of it all, I could tell many stories about the ins and outs of this, but the interesting outcome of it all was the US Federal Court ceded jurisdiction in favour of the Irish Court and felt the Irish Court was a more appropriate court to deal with a very large piece of litigation. And as often happens with very large litigation, the case ultimately ran for about 5 or 6 weeks, and then the parties settled their differences. But there's still other bits, I think, of that Madoff litigation doing the rounds of the Irish courts. But I think that was a sign of confidence that the Irish courts were perfectly well able to handle large-scale commercial litigation. We've experienced commercial judges. And if I might add one comment to all of that, obviously scaling up anything takes a certain amount of work. But in my experience of dealing with Irish government over the last number of months in this context, obviously, and it would hardly be a surprise, Irish government is very focused on the Brexit issue at the moment. And certainly if a credible case is made to government that more resources are needed in a particular area to deal with Brexit-related issues, it's my experience that there's a much more open attitude to providing those resources. They're not being thrown at the question, but if you make a real case that they're needed, they are being made available. From my perspective, I suspect that if I'd gone a year ago and said we need more judges in the commercial court, the answer would have been, well, so do we need more hospitals and more schools and more lots of things. Why should you get them rather than anyone else? If you go today and make the same case but say we really need this because of Brexit-related issues, the answer is, oh, is that enough? Would you like some more? So I actually think that government is on the right page in this context. If we need to upscale the commercial court to deal with an increase in the amount of litigation, I think the resources will be there. And that leads to another point. Do we have the legal expertise to handle this? Well, firstly, I do think that the Irish Bar and the Irish solicitors have shown an ability to deal with the most complex of commercial litigation. If you speak to judges of the European Court, as I now do in the context of the 255 committee that was just mentioned, I think along with the English Bar, the Irish Bar would be regarded as amongst the best advocates that the European Court feel come before them. So I think we can hold our own. But if there is a question of scale, there's a long tradition in Ireland of lawyers from other countries being able to come on a case-by-case basis if necessary, particularly if there's areas of special expertise needed. Again, when I was a judge of the commercial court, we would have a relatively small amount of patent litigation in Ireland. growing amount in some areas such as pharma, where Ireland does have a significant business and where there's a number of generic producers who are looking for ways round patents of the large multinationals. But it wouldn't be unusual for, at least in some cases, one of the parties to be represented by London Council in a patent case, because we all know the London Bar has great expertise in that area. And likewise, if, as was mentioned earlier, the Irish corporate recovery model of examinership becomes something that people look at as a means of large-scale transnational corporate restructuring, then there's no doubt that expertise is there in the Irish accountancy business, but also all of the big Irish accountancy firms have contacts in or arrangements with other firms in other countries. They're often part of larger multinational firms, and personnel can be transferred. So I have no doubt that if the demand is there, both in terms of expanding the judiciary with high quality commercial judges and the current and perhaps increased availability, if necessary, by initially at least people with expertise from outside coming in, I think it can be handled. There is probably a limit. If the business were to increase fivefold, I couldn't guarantee that we would be up to that level of expansion. But I think there is the capacity to maintain what I think is the established quality of the Irish courts litigation system to a significantly expanded scale, without, as I say, interfering with the quality. So I think the moral of all of that is that there is an opportunity for Ireland to build a significantly greater presence in international dispute resolution. I think we already have the expertise to do it. There is the willingness to expand as necessary to meet the needs. And the very fact that we can provide the certainty that come next April, after the first Brexit deadline, or perhaps come January 2021, after the proposed transition period, if it's agreed, comes to an end, we will certainly be in the EU. We will certainly be a common law country, providing litigation in a system with which anyone from another common law country would be familiar, and we do kind of speak reasonably okay English, I think, so that the building blocks are there, I think, to make a reasonable pitch for any business that may find that it no longer is comfortable being conducted in London because the UK is no longer a member of the EU. Just as in financial services, I suspect we'll have competitors for this business. We've had the fact that the Paris Commercial Court has recently, interestingly, set up a division which allows people to plead in English. And the idea of a French court being happy to have cases done in English is an interesting concept given historical questions. I wonder what Napoleon would have thought when he was writing the Code Napoleon about there being courts within this system which were allowed to conduct their business in English. So I'm not suggesting we're the only show in town, but I think we have unique advantages that are not available to everyone else. And the one thing I can certainly say on behalf of the court system, and perhaps to an extent even the Irish legal system as a whole, is that we are ready and willing, and in my view very able, to take up any slack that becomes available as a result of Brexit. So I think there'll be a more detailed debate about some of these issues tomorrow. But I'd like to, as we might say in Ireland, throw the ball in by indicating that we're up for the game, and we're very glad to have you here to explain to you just how up for the game we are. Thank you very much.